We hear about so many people whose aging parents, well, for whatever reason, they don't have a will. And when that happens, so many of them say, oh, well, y'all can just sort it out after I
Hmm.
die.
Hmm.
But that makes it so difficult for so many people.
Right. It can get pretty
Yes.
complicated. Today, we're bringing in Jeff Barnett with Barnett and Luty Law Firm to talk about what happens when you don't have a will. So, Jeff, let's start with what happens when somebody passes away and there's not a will.
Well, the classic lawyer answer is, well, it depends.
So, let's start with the simplest. What's maybe the simplest process or simplest
So,
situation?
yeah, if you happen to strike it lucky and the person, maybe named all, maybe didn't have any real estate, all they have is money or a brokerage account and money and stuff like that, and they named beneficiaries on those accounts, then it could be that no probate is needed at all. Or if they did happen to have real estate and by some weird chance they happen to have a ladybird deed or a transfer on death deed, then it could transfer that way, and the bank accounts or the other accounts can transfer, by transfer on death or pay on death.
Mhm.
But that's the most simple. And if you don't happen to be that lucky, then there are situations that that either involve the court or involve an attorney drafting documents for you and recording them with the clerk's office. So you start out next, I guess, with the next more complicated, and that would be the small estate affidavit. If someone dies with less than $75,000 in assets, not counting a house, if they happen to own a house,
Mhm.
and there's other types of assets, but we won't go into all that. But the $75,000 is the main threshold, and if you have less than that, then you may be able to qualify for something called a small estate affidavit.
Mhm.
And normally, a small estate affidavit can't transfer real estate like a home. But if the only surviving, the surviving beneficiary or the surviving heir on the small estate affidavit is a spouse,
Mhm.
and also a dependent child could also qualify for that. Then it can transfer real estate.
So with that small
And
estate, so not to interrupt you, but that small estate affidavit, is that something you still you petition before the court? You need an attorney to help you with?
Yes, so it's basically an affidavit that recites for the court who all the heirs are of the person, and it's got to be signed by two disinterested witnesses, somebody who is not really part of the family, or if it is part of the family, it's somebody really distant.
Mhm.
But the trick is, the caveat is that while they've got to be distant like that, they have to know the family history. They have to be able to truthfully attest to the fact that, oh, these are the person's truthful heirs, the actual
Mhm.
heirs.
Hmm.
Okay. And you still go before the court to do that.
You still go, well, you file the document with the court, and then if the court doesn't have any problem with it, if they don't have an issue, then basically the court will just sign an order approving that small estate affidavit, and then you go and you get it recorded in the county clerk's office if
Mhm.
you need to uh, transfer real estate, or you just get certified copies of it and you take it to the bank or you take it to the brokerage company, that kind of thing.
Okay.
Got it.
Let's go back to if you don't have a will and you don't have anything else. You don't have the ladybird deed. You don't have the affidavits. You haven't done anything with your bank. How difficult is it?
So then it definitely gets a lot more complicated. Let me run back to one other little thing that I didn't touch on yet on and that's something called an heirship affidavit, and that's not to be confused with where I'm about to go in answer to your question right there. An
Okay.
heirship affidavit is an affidavit that looks very similar to that small estate affidavit, but this doesn't get filed with the court. It does get signed by two disinterested witnesses, but then it gets recorded in the county clerk's office,
Hmm.
and usually the piece of real estate or the pieces of real estate that the person had also are stated in the document, and then it gets recorded in the county clerk's records, and it can act as if it were a deed. There are some title companies that don't like those, so occasionally that's not going to be the best solution, an ideal solution.
Mm-hmm.
But most of the time that can pass muster if that's the situation.
Okay.
And
Now let's get to the other thing. Oh,
yeah, because those are all situations that you described are all ways to avoid typical probate.
right.
The ones
Right.
that
All of
we've
those
already
are
talked about.
avoiding, probate. I mean, the small estate affidavit does get filed with the court, but there's no hearings. There's no complex situations with the court. Nothing to do that,
Mhm.
that causes things to get complicated or expensive.
Okay.
So now the other thing that you asked, okay, so what if they, have real estate, or, their estate isn't just $75,000, or it gets, more complicated. Then you've got to go through a proceeding called an heirship determination.
Hmm.
And that's not like a rocket ship, AIRSHIP. That's an HEIR
Mhm.
heirship,
Yeah.
as in somebody's heirs. So it's a determination of who someone's heirs are. And, the people that are in, the immediate family of that person, of course, may know who the immediate family is, who the heirs are, but the court doesn't know. So
Mhm.
they have to do this proceeding, and you file a petition, an application to determine the person's heirs. The court appoints somebody called an attorney ad litem, who does an independent investigation as to who the person's heirs are. They contact the family members. They contact disinterested witnesses and disinterested people,
Mhm.
and they ultimately help guide the court. They produce a report for the court, to help the court make its final determination of who the person's heirs are. And then the court ultimately, after a hearing, sometimes a contested hearing, if there's some kind of dispute over who the heirs are or something like that. But the court has a hearing, and then the court signs an order stating who the heirs are and who gets what percentage of the estate, and that's all determined by state law.
Mhm.
That kind of follows the thing that we lawyers like to say, that if you don't have a will, the state of Texas has one for you, and it may not be exactly what you want it to be. So
Yeah.
yeah, there's a statute that just says exactly who gets in what order, if somebody dies without a will, and it depends on whether they were married, or if they had previous marriages, and if they had kids from previous marriages, or if
Sure.
all the kids are from this marriage, or if they're not married. So it's all different kinds of circumstances. And anyway, so there's the heirship determination, and then and I told you that the court makes that order. And then if it's just a matter of transferring, some real estate or something like that, you may not need administration with that. And so you may just get that order, and
Mhm.
get a certified copy of it, record it in the county clerk's office, and then you're done. Um, or if there is a need for administration, in other words, there's a need for somebody to be in charge, like an executor,
Mhm.
but it's just somebody that has the more generic term, of a personal representative, or an administrator. And if there's a need for that, because there's more complex situations that need to be addressed, then in addition to the determination of heirship, the court you have to apply to be an administrator in the case.
Hmm.
And it's usually the same person that would make an application to determine the heirs, so it's not more people involved or whatever. But and if everybody can agree
Mhm.
on who that person's going to be, then it does become a little bit simpler, but there's still
Yeah.
extra complexities and whatever. If everybody doesn't agree, and there's a fight over who's going to be the administrator, then it gets ugly.
Oh, I bet. And we know that with a will, it goes through probate. Is the determination of heirship, is that an even longer process than probate?
Very much so. So while a probate with a will, takes anywhere in Texas, from 50 to 75 days, maybe 90 at the outside. In most cases,
Mhm.
an heirship determination can easily last 6, 8, 9 months, and
Oh,
even longer, depending upon. And that's when it's uncontested. If
Yeah.
it's contested and there's a fight, and you take depositions, and you have a big old fight, and all that kind of stuff, it can take months, or even it can even go into years.
wow. So it definitely gets really, really complicated. And for somebody who has a lot of assets, you could see the value of having a will. especially if it's just that you want specific people to get specific things. Because I think what I'm hearing
Right.
you say is that based on the law, the judge or the court is just going to say, well, you're the spouse, so you get X percentage. You're the two children, so you get this percentage. You're a grandchild, or I don't even know how if it goes down that far, but they're basically saying that the whatever things that dad might have said just in
Mhm.
passing verbally don't necessarily
Doesn't
matter
matter.
anymore.
Doesn't matter at all. In fact, I've even had people who come in to see me to get a will done, and they're like, "What if I die before you even get this drafted?" And I'm like, and they're like, "Will that matter? I came here and I told you, and you wrote it all down." No, it's even if that's the case, and I have a clear picture of what's going to be in the will.
Mm-hmm.
It doesn't matter. So yeah, it doesn't matter, whether they've expressed it orally or whatever. There is something, that it's beyond the scope of what we're doing here. But if someone wants to do a holographic will, a will completely in their own handwriting,
Mm.
that can be. But no, I mean, outside of what we're talking about here,
Yeah.
yeah, it just gets complicated.
I
If
mean,
there is a situation like that.
can you give us a scenario that is a like maybe a common one that you've seen, whether there's second marriages or things like that, where without a will it can just
It can get really ugly and
the
dirty.
step kid ends up getting money from this situation because there just wasn't you're again the judge is just going down the list.
Yeah, stepkids, are normally, not heirs of any kind, and so, stepkids, even if they were, as close as the other, person's, I mean, as the person's other children,
Yeah.
don't make any difference at all, to the court. And when yeah, it can definitely get complicated because it's not just, whether it's whether you're married or whether it's a second marriage, and whether it's, you have kids from this marriage or kids from a prior marriage, and but it also gets down to, do you have community property and do you have separate property?
Hmm.
And again, that's, kind of getting beyond the scope of this interview, but yeah, I mean, there's so many different factors and that come into play. And so, there's lots of things to fight about. There's lots of things, that may, end up in uh, um, convoluted situations where people receive something that maybe, we're not at all close to the person who died,
Yeah.
or maybe, people receive it, to the detriment of the surviving spouse. The surviving spouse may not have enough to live the rest of her life or the rest of his life, and because the kids from the prior marriage got half of the estate, or something like that. So
You could
yeah,
have an estranged child or an estranged relative potentially. I
that
think what
too.
you're saying is it could get money, could end up getting part of that maybe that wouldn't have been
Wouldn't have been their
kind of
choice.
the intent. Yeah.
Yeah.
So it does. So yeah, it gets really complicated if you want people to be able to get what it is that you want them to. And I would imagine, as you're saying that, regular probate runs, a couple of months typically, if you're looking at 6 to 8 months or more going through this process, that also gets pretty expensive. And is that
Oh
something you
yeah.
really need an attorney to help you walk through, or is that something that people do on their own, or do you really need an
They
attorney?
cannot do it on their own, in Texas. In some small counties, if somebody's probating a simple will, or somebody has a very simple kind of situation, maybe a small estate affidavit, some small counties, the judge will let somebody proceed without an attorney, but not in Travis, not in Williamson, not in Dallas or Houston or any of the metros of those areas. You have to
Yeah.
get really far out in, like, way West Texas or up in the Panhandle,
Yeah.
for a judge to be, lenient in that regard. Most
Sure.
most decent sized communities, the judge is going to make you get an attorney, and yes, with an heirship, yeah, it does get a lot more expensive.
Yeah.
Sure. Then the will would have been to start with.
Exactly.
Oh, way more expensive. I mean, wills are only, five, $600, $700, whatever. I mean, it's not an expensive thing. This is many thousands of dollars, and it, like, I mean, a minimum one, in our office is something like the, $6,000 to $8,000. I mean, and that's going absolutely smoothly
Hmm.
and without any contest or anything like that. If
Yeah.
it drags and whatever, it can easily be over $10,000, $15,000.
Wow.
Well,
Well,
finally, Jeff, speaking of money, with all of your experience in estate law, I know you've seen people who say, well, I don't want to spend the money to get a will, or I'm just not interested in getting a will, or I don't want to talk about getting a will.
Or I'll let y'all figure it out later.
Yeah. How do you convince them?
You know, you got to find what is their, their sensitive point, in the sense of, sometimes it's about control.
Mhm.
Sometimes it's about privacy. Sometimes it is about, it's about their legacy or whatever, but well, sometimes they don't understand, that their legacy may not go the way that they want, if they don't have one, so it's really just sitting down and explaining to them, hey, this is your opportunity to, control your own legacy, and to leave, to protect your surviving spouse. Don't you want to make things easy on mom? Don't you want to make things easy on your wife? Maybe it's the second wife, and it's even, stepkids that are talking to dad or whatever. Don't you want to make it easy on your wife? When you pass, you don't want her to, go through and make people, or have people get your estate that you really don't want to have your estate,
Mhm.
at least at that time.
Mhm.
Anyway, it's tough. It's sensitive to, it's a sensitive topic. People don't want to face their own mortality.
Oh, sure.
But none of us get out of this life alive, and people, have to realize that, and the earlier they realize it, the better, because like we've said in numerous occasions, it's you don't know what your day is.
Yeah.
Your day could be tomorrow. Your day could be 2 weeks from now, or 2 months from now. It doesn't have to be 40, 50 years from now. And oh, I've got lots of time.
Yeah.
It could be sooner, and you never know.
Yeah.
Yeah. Yeah.
Well, great advice as always. Jeff Barnett, thanks so much for joining us today.
All right, you're welcome. Thank you.
I tell you what, I think what we learn here is that to protect, like Jeff said, your legacy, you just have to go to the whether it's the expense or the effort, to make sure that everything is settled, everything is handled, because you want to do what's best for your family.
Absolutely. And most parents, at the end of the day, they would want that. Sometimes they may just need help understanding what the implications are and the complexities that are involved if they don't.
Exactly.
Yeah.
If you have any other topics you'd like us to discuss, please let us know. Parenting aging parents.